Last week, Brandon wrote about mortgage fraud and how, if you are convicted of mortgage fraud, how bankruptcy will not help the person eliminate that debt by their discharge from bankruptcy. This week, Brandon writes about a recent decision of the Ontario Superior Court of Justice on fraudulent misrepresentation. And the bottom line is the same. If you're found guilty of fraudulent misrepresentation and therefore the other party suffered damages, that debt will not be released by an order of discharge. My name is Ira Smith, president of Ira Smith Trustee and Receiver, Inc. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you. Now, even though I've given you the bottom line, I hope you can watch until the end of this video, because I know you will find it informative. This week's Brandon's blog is titled Fraudulent Misrepresentation, our authoritative guide on what really goes into fraudulent misrepresentation. So first, Brandon gives an overview of what fraudulent misrepresentation is. He discusses the three types of misrepresentation, of which fraudulent misrepresentation is one. He then discusses what are the legal consequences of making false statements. Then he gets into the court case. What's the process for suing someone for fraudulent misrepresentation? And Brandon describes the court case, how it started. Bank of Montreal started with a notice of motion suing a company and its director, who was also the guarantor of the company's debts. He goes through the evidence that was brought out for fraudulent misrepresentation in the court case. The company and the director did not defend, so the Bank of Montreal was able to get judgment based on its evidence alone. And the company had applied for 3 different loan facilities. The first one, being the main one, was under the Canada Small Business Administration Financing Act. And the company made certain representations, declarations in writing to Bank of Montreal and supplied an invoice for the equipment it purportedly purchased. It turns out those declarations were all false and the invoice was fraudulent. The invoice was not real and the company never bought any equipment at all, let alone any equipment that would qualify under the Canadian government loan program. So Bank of Montreal was able to prove by its own evidence fraudulent misrepresentation. It got judgment not only for the full amount owed from all 3 loan facilities, but also punitive damages were awarded to the bank. And the bank also got a declaration that the debt owed was a result of fraudulent misrepresentation. The judge went through a careful analysis for the claim of fraudulent misrepresentation, and he even discussed the 5 elements of a fraudulent misrepresentation claim that Brandon discusses down below. The judge even noted that although Bank of Montreal did not ask for a declaration that the debt survives any bankruptcy of the director under Section 178(1)(e) E of the Bankruptcy and Insolvency Act, it is clear on the face of the evidence that it would be such a debt. So if the director ever files for bankruptcy, then based on last week's case Brandon described, Bank of Montreal can certainly go back to court and get either the existing judgment amended or a new judgment declaring the debt to fall under the category of fraudulent misrepresentation, which under Section 178(1)(e) of the BIA is not discharged upon the person's discharge from bankruptcy. So I hope you can read the entire Brandon's blog below, because I know you will get value from it. Again, both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to hear from you.